Good morning. And it was already mentioned by Katarzyna Zambory. My name is Bartłomiej Oręziak, and I'm a PhD at the Legal Sciences and a member of the Professors Network 2022, coordinated by the University of Miskolc Central European Academy. Exactly in the research group Right to Privacy, headed by Professor Marcin Wielec, and in fact this is the reason I'm talking to you here in this beautiful building of Hungarian Academy of Sciences in Budapest. So before I start my presentation, I would like to extremely congratulate and thanks to organizers for today's conference. It's impressive, and I know that it was very hard work and it should be appreciated. Thank you so much. But now going to the topic of my speech today, I will be talking about the range of the right to privacy in the light of selected Polish constitutional court cases. My aim is to present you the interpretation of law according to the right to privacy made by the Polish Constitutional Court, but it must wait just a short while. Why? Because in my opinion, firstly, there is need to present you legal basis of the right to privacy in Polish constitutional law, exactly in Polish constitution. This will be very short legal regulatory framework. So in Polish constitution, we have some legal norms relevant for the right to privacy. The most important legal norm directly defining the right to privacy is Article 47 of the Polish Constitution, according to which, as you can see, everyone shall have the right to legal protection of his private and family life, of his honor and good reputation, and to make decisions about his personal life. And this is the fundamental one, of course. However, Polish constitution also provides other, but in this case more detailed legal norms that constitutes maybe next phases of the right to privacy in Poland. I'm thinking about Article 48 of the Polish constitution, according to which, as you can see, parents shall have the right to rear their children in accordance with their own convictions. Such upbringing shall respect the degree of maturity of a child, as well as his freedom of conscience and belief, and also his convictions. And there is also paragraph 2, limitation or deprivation of parental rights may be affected only in the instance specified by statute and only on the basis of a final court judgment. And in Polish constitution, we have also the basis for the privacy of communication. That is the Article 49 of the Constitution of the Republic of Poland, according to which the freedom and privacy of communication shall be ensured. Any limitation thereon may be imposed only in cases and in a manner specified by statute. And also we have Article 50 of the Constitution of the Republic of Poland. That is the inviolability of the home, according to which the inviolability of the home shall be ensured, and any search of a home, premises or vehicles may be made only in cases and in a manner specified by statute. And last but not least, Article 51 of the Constitution of the Republic of Poland. This is the protection of personal data and protection of information autonomy. As you can see, 5 paragraphs. No one may be obliged, except of the basis of statute, to disclose information concerning his person. Public authorities shall not acquire, collect, or make accessible information on citizens other than that which is necessary in a democratic state, ruled by law, of course, and everyone shall have a right to access to official documents and data collections concerning himself. Limitation upon such rights may be established by statute, and everyone shall have the right to demand the correction or deletion of untrue or incomplete information or information acquired by means contrary to statute. And last, paragraph 5. This is the principles and procedures for collection of and access to information shall be specified by statute. This is important according to the judgments of the Polish Constitutional Court cases, because this is direct basis of the Constitution of the Republic of Poland, which is interpreted by the Polish constitutional card. And as you can see, cited legal regulations consist more detailed phases of constitutional right to privacy. This is not only Article 47. These more detailed phases are, as I mentioned, parents' rights, parental rights, privacy of communication, the inviolability of the home, and the protection of personal data. And once we know what the constitutional basis for the right to privacy in Poland is, we can talk about how the Polish constitutional card understands the right to privacy. So I decided to select this judgment. This is on 12th December 2005, the Polish Constitutional Court issued a judgment on the conflict that may occur between the operational activities of the police and the fundamental rights of an individual. So in this case, here, what in my opinion is not a surprise, Polish Constitutional Court noted that the operational activities of the police, which are based on ordinary legislation, of course, naturally, implemented in condition of secrecy, is in obvious conflict with curtain fundamental rights of the individual. And the Polish Constitutional Court stressed that this applies in particular to the right of the individual to privacy. And its more detailed phases, it is freedom and privacy of communication and protection of information autonomy. The basis is what I already mentioned, Article 49 and 51 of the Polish Constitution, but as well as the constitutional guarantee of judicial protection of individual rights. Ladies and gentlemen, in this case, Polish Constitutional Court pointed to one very important aspect of the right to privacy in Poland. Namely, it should be noted that some of the rights and freedoms provided for in Polish Constitution, as you can see at previous slides, contain a reference to ordinary legislation which may determine the limitations of these rights and freedoms. Such situation was in Article 49, privacy of communication. It was connected to the ordinary statute. And 50, the inviolability of the home in Polish Constitution. While other legal regulations, as you can see, such as Article 47, that is generalized right to privacy of the Polish Constitution, do not provide the possibility of statutory limitations of these constitutional rights. Nevertheless, in Poland, in Constitution, there is a provision of Article 31, paragraph 3 of Polish Constitution, which is the general principle of maintaining a proportionality of a possible restriction of constitutional freedom and rights if they are to be limited in ordinary legislation. I would like to cite this Article 31, paragraph 3 of Polish Constitution. That is, any limitation upon the exercise of constitutional freedoms and rights may be imposed only by statute and only when necessary in a democratic state for the protection of its security or public order or to protect the natural environment, health or public morals, or the freedoms and rights of other persons. Such limitations shall not violate the essence of freedoms and rights. Polish Constitutional Court noted in this case, yes, that this principle from Article 41 of Polish Constitution applies both to the situation where Polish Constitution provides for the creation of exceptions itself by statutes and the situation where the ordinary legislator regulating another matter and not exercising the constitutional authorization to co-define a curtain sphere somehow accidentally falls into collision with constitutional freedoms and rights of the individual. And this observation also applies to the rights and freedoms provided for in Polish Constitution, which have been rigorously formulated, like similar to the generalized right to privacy from Article 47 of the Polish Constitution. We are talking here about a situation in which Polish Constitution itself does not provide that the law may limit a specific right or freedom. In this context, if the law interferes with such rights or freedoms, it is necessary to maintain proportion. And going beyond this proportionality of the restriction will be decisive for the conclusion that the interference by the ordinary legislator took place in an excessive and therefore unconstitutional manner. And these are important, in my opinion, conclusions in the interpretation of the right to privacy deriving from this single ruling of Polish Constitutional Court. But I selected one more. This is another noteworthy ruling, is the judgment of Polish Constitutional Court of 5 March 2013 on undergoing medical examinations or performing activities with the participation of the accused and the suspect. What was the case here? Here the case was fact that the examination of the accused person or suspect may be carried out in the presence of third parties. And in order to conduct the examination, direct coercive measures may be used. In the opinion of Polish Constitutional Court, what is important, Article 47 of Polish Constitution defines not one, but two separate human rights. Firstly, the right of an individual to legal protection of the spheres of life indicated in the first part of this provision. It is private life, family life, honor, good name. Second, we are talking about the freedom to decide about your personal life. Polish Constitutional Court took the position that the first right, in this case, of an individual must be accompanied by statutory regulations allowing the protection of privacy, family life, honor and good name. The second, on the other hand, means that it is forbidden to interfere with the freedom of an individual to shape his or her personal life. And what is important, in these circumstances, Polish Constitutional Court stated that these two rights provided for in Article 47 of Polish Constitution should be defined jointly as the right to privacy. Polish Constitutional Court also drew attention to the fact that Polish Constitution itself emphasized the importance of the right to privacy in the system of constitutional protection of rights and freedoms. Why? Because pursuant to Article 233, paragraph 1 of Polish Constitution, the right to privacy in Poland is inviolable, even in the event of a state of emergency or material law. Therefore, it should be emphasized that even such exceptional circumstances cannot constitute a justification for the ordinary legislator to mitigate the premises legitimizing, ensuring, entering the sphere of private life without risking the accusation of unconstitutional arbitrariness. And referring to the elements of the right to privacy, Polish Constitutional Court noted that the right to privacy in Poland is protected in many ways. I indicated this in previous slides. The multi-faced nature of this right is manifested in the fact that it is protected by several constitutional rights and freedoms and is closely related to the constitutional order to protect human dignity provided in Article 30 of Polish Constitution. These constitutional rights and freedoms are contained in Article from 47 to Article 51 of Polish Constitution, what I already presented. And these are other important observation resulting from the interpretation of legal norms related to the right to privacy. And these interpretations contained in the judgments are important because they are judgments of the Polish Constitutional Court, which in Poland is the only one and exclusive entity competent to interpret Polish Constitution. So far, two rulings presented are from 2005 and 2013. Now it is time, in my opinion, for one of the more recent rulings. On 25 November 2021, Polish Constitutional Court issued a judgment on a declaration of property status of public officials and relatives. And here, Polish Constitutional Court noted that in its latest jurisprudence, it had already pointed out that the constitution maker established the privacy of an individual, not as a constitutionally granted subjective right, but as a constitutionally protected freedom, with all the resulting consequences. This is important because in the case of subjective right, an individual should have an appropriate entitlement resulting from a legal norm that defines the content and scope of this right. It is important that in the event of a conflict of the constitutional freedom of an individual with the subjective right of another, the subjective right should give way to freedom, at least until the legislator resolves the conflict in favor of the subjective right, while respecting the principle of proportionality, of course. Polish Constitutional Court also noted that the privacy relates primarily to personal, family, and social life and is sometimes defined as the right to be left alone. However, it should be emphasized that privacy also refers to the protection of information about a person and guarantees a certain state of independence, within which an individual can decide on the scope and the range of sharing the communicating information about her life to other people. Polish Constitutional Court said in this case that privacy also has a special relationship with human dignity, since the inviolability of human dignity requires, above all, respect for the purely personal sphere in which he or she is not exposed to the necessity of being with others or sharing his or her experiences or sensations of an intimate nature. Polish Constitutional Court at least indicated that a special breach in the sphere of the right to privacy is created by Article 61 of the Polish Constitution and the right of access to public information guaranteed therein. However, this provision, also in the opinion of Polish Constitutional Court, concerns only the privacy of persons charging public functions. The interference of public authorities with the private life of individual not performing public function is subject to much more restrictive restrictions. In this regard, Polish Constitutional Court expressed the view that it is citing obtaining information about the private life of individuals by public authorities, especially covertly, must be limited to necessary situations, permissible in a democratic state only for the protection of constitutionally recognized values and in accordance with the principle of proportionality. So, ladies and gentlemen, time is running out, so I should move to a very quick summary, and it will be a few sentences. In Poland, as you can see, as you can hear it, we have the right to privacy provided for in Polish Constitution. We have a very strong legal basis. The creators of Polish Constitution, what is interesting and important, wanted to strongly emphasize the importance of the right to privacy by dedicating not one, but several provisions. To it, we lawyers, on the other side, know perfectly well that the role of the jurisprudence is indispensable. The fact that the Polish Constitutional Court has issued several rulings on the right to privacy confirms that these human rights has a special place in the Polish legal order. These rulings become even more important when we once again recall that in Poland, only Polish Constitutional Court has the power to interpret Polish Constitution in a binding manner. Ladies and gentlemen, the right to privacy in the jurisprudence of Polish Constitutional Court is presented as an important and key element of the protection of rights and freedoms. The scope, meaning, and elements of the right to privacy affect the lives of every human being and should be, what is obvious, effectively protected in direct proportion to emerging threats. Human privacy is one of these currently attacked aspects of human life, the defense of which is the interest of the autonomy or even sovereignty of each person. This is of course true. but always is some but. The right to privacy is an important right, but it is not an absolute right in Poland. This means that some restriction can be introduced, but only those that do not kill the essence of the right to privacy. And this accent, I would like to end my speech, and thank you very much for your attention.